Welcome back to USA State. There is a headline spreading online right now claiming that United States Citizenship and Immigration Services, USCIS, will start charging $100,000 for green card approvals starting in July 2026. This claim has been shared thousands of times across social media, and understandably, it has caused panic among green card applicants, sponsoring family members, and employers alike. But here is the real question. Is this actually true? In this video, we are going to break down exactly where this rumor came from, what the real policy actually says, who it truly affects, and what green card applicants really need to worry about in 2026. If you are interested in this topic and liking this video, please stay tuned until end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. Let's take a closer look at where this rumor is coming from. In September 2025, President Trump signed a proclamation titled Restriction on Entry of Certain Non-Immigrant Workers. This proclamation created a new $100,000 fee, but here is what you need to know. That fee applies to certain H-1B visa petitions, which is a non-immigrant work visa category, not to green cards. According to sources, the proclamation took effect at 12:01 a.m. Eastern Daylight Time on September 21, 2025. Reports suggest that widespread confusion followed the announcement, with some H-1B visa holders even canceling travel plans out of fear the fee applied to them. However, before jumping to conclusions, USCIS issued clarifying guidance on October 20, 2025, that narrowed exactly who this fee applies to. Somewhere between the original headlines and the retellings on social media, the H-1B fee got mixed up with green cards, and that is likely how this misconception started. So who does the real $100,000 fee actually apply to? According to USCIS guidance, it applies to new H-1B petitions filed on or after September 21, 2025, for beneficiaries who are outside the United States and who do not already hold a valid H-1B visa. It also applies to petitions that request consular notification, port of entry notification, or pre-flight inspection for someone currently inside the United States. What this translates to is a fee aimed specifically at new H-1B hires coming from abroad, not at people already living in the United States and not at anyone applying for permanent residency. In practical terms, the fee does not apply to several important groups. It does not apply to people who already hold a valid, unexpired H-1B visa. It does not apply to H-1B extensions of stay. It does not apply to amendments filed for workers already inside the United States, and it does not apply to change of status petitions, such as an F-1 student on optional practical training who is switching into H-1B status while remaining in the country. Immigration experts note that this fee was designed to affect new H-1B beneficiaries applying from outside the United States during the upcoming lottery cycle, not the broader immigrant visa or green card system. Now let's talk about green cards specifically, because that is really what brought you to this video. As of 2026, there has been no new fee announced by USCIS that charges $100,000 for green card approvals. The actual government filing fees for a green card remain in the low thousands of dollars, not six figures. For a family-based green card, applicants are generally filing Form Y-130, the petition for alien relative, along with Form Y-485, the application to register permanent residence or adjust status. Based on current fee schedules, the I-130 petition costs around $625 when filed online, and the I-485 adjustment of status application runs around $1,440. Add in the standard immigrant fee of $220 for those processing from abroad, along with biometrics and a medical exam, and you are typically looking at a total cost in the range of $2,000 to $5,000, depending on the category. That is a significant amount for many families, but it is nowhere close to $100,000. While there have been some modifications to immigration fees in 2026, they came from a different source entirely. Legislation known as H.R. 1, signed into law in July 2025, created new statutory fees tied specifically to asylum applications, temporary protected status, and parole cases. This includes a new $100 asylum filing fee and a $100 annual asylum fee that applicants must pay to maintain their pending cases. USCIS also applied a routine inflation adjustment to certain fees on January 1, 2026, based on a 2.7% increase in the Consumer Price Index. None of these changes come anywhere close to $100,000, and none of them apply to standard green card processing. Despite these clarifications, it is completely understandable why so many people got worried. Advocacy groups warn that headlines involving large, round dollar figures spread far faster online than the detailed clarifications that follow them. And in a year that has already seen major immigration policy shifts, including new fees, new enforcement priorities, and ongoing litigation, it makes sense that people would believe almost anything could be next. As a green card applicant or petitioner, this situation might feel overwhelming, especially when you are trying to figure out which news is real and which is exaggerated. There is also a broader implication worth discussing here. Multiple lawsuits have already been filed challenging the H-1B proclamation itself, with legal analysts suggesting the fee structure may face continued court scrutiny throughout 2026. That means even the real $100,000 H-1B fee is not necessarily permanent or settled law. Officials argue the fee is meant to discourage what they describe as abuse of the H-1B program, while critics and employer groups argue it functions more like a tax on hiring skilled foreign workers and could push companies to look elsewhere for talent. Legal analysts also note that the Department of Homeland Security Secretary retains authority to waive the fee in extraordinarily rare cases, though details on how that waiver process works in practice remain limited. So what does this mean for you if you are currently in the green card process? In practical terms, nothing has changed regarding your filing fees because of this rumor. If you are working through consular processing with the DS-260 immigrant visa application or adjusting status inside the United States with Form Y-485, you should continue following the current, official USCIS fee schedule, which you can always verify directly on USCIS.gov before submitting any payment. If you are an H-1B worker or an employer sponsoring one, the $100,000 fee is the real policy to pay attention to, and it remains worth speaking with a qualified immigration attorney about whether your specific petition falls under the exemptions we covered earlier, such as extensions, amendments, or change of status filings. To put this in perspective, the biggest danger in immigration right now is not necessarily the policies themselves, it is misinformation about those policies. A rumor like this one can cause people to delay legitimate applications out of fear, or worse, fall for scams from bad actors claiming they can help you avoid a fee that never actually applied to you in the first place. The real advice here is simple. Always verify major fee changes directly through official USCIS announcements or a licensed immigration attorney before making any decisions based on a viral headline. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.